Something I do quite a bit is not just helping individuals exit Australia, but it's take those businesses with them as well. There's no exemptions for stuffing this up though, so you've got to be really careful and you've got to get the right advice. Depending on your kind of business, if you've got physical assets in Australia like a shop front or a warehouse or a factory, you can't effectively offshore that value, because no matter what you do, if you put it in a foreign company, it's still going to be a permanent establishment, which is a taxable presence in Australia of a foreign company. But if you don't have premises in Australia, you just sell into Australia, then you probably can get that business out. If it's already in an Aussie company or an Aussie trust, you can simply just sell it across to yourself. Depending on the value, you might be able to claim the small business CGT concessions. If you can't do that, you may instead want to set up the international branch overseas, build that value, take over some of those sales in Australia, and eventually you can transfer that business at hopefully a relatively low valuation. Those existing profits in Australia, if they're in a company and you pay a dividend, you usually get a 25% tax rate. That's it. If it's coming from a trust, however, that you trade in, you may have some problems. So you may want to restructure before you start distributing those profits. So you do a 122A rollover to put that business held in the trust into a subsidiary company so that you can effectively get a pretty decent tax rate while you're a non-resident. But it always depends on the kind of business that you run, what you do, where the assets are that run the business.